Hey everyone, welcome back to the channel. My name is Gaurav and today we are looking at Bill 60 and how it affects people who hope to own a home that earns rental income. Whether you're looking to buy a property with a basement rental or looking to make an investment in the future, this video talks about the laws which impact you as a landlord. In one of my previous videos, we compared multiple rent versus buy scenarios to see which option truly builds more wealth. And the clear winner was buying a home with a legal basement rental. That extra income can completely change your financial trajectory. If you're curious to learn when buying is better than renting, then you can watch that video. The link is in the description. But understanding the opportunity is one thing. Feeling confident enough to actually rent your basement is another. There is one thing that stops a lot of first-time buyers from renting their basement, and you've probably heard it too. The system always favors the tenant. Now, if you've stretched your budget to buy a home, the last thing you want is uncertainty. That is, a tenant who stops paying rent while you're stuck covering the mortgage, utilities, and every other household cost. And that fear didn't come from nowhere. For years, Ontario's rental rules were designed to strongly protect tenants. If rent was late, the process landlords had to follow could be painfully slow. Even when a tenant clearly broke the agreement, the resolution could take months, and during that time, the landlord was completely on the hook financially. But something significant has changed. In late 2025, Ontario passed Bill 60, the Fighting Delays Building Faster Act. Bill 60 is Ontario's new housing reform law designed to speed up both rental dispute resolution and home constructions. For landlords, it speeds up action when rent isn't paid, shortens appeal timelines, and stops tenants from delaying hearings with unrelated complaints. Beyond rentals, Bill 60 helps speed up home construction by cutting approval delays on new development, streamlining municipal planning, and reducing red tape for adding more housing. All of this is aimed at improving long-term housing supply and affordability. But for the purpose of this video, we are going to focus specifically on rental-related changes, the ones that directly affect you as a current or potential landlord. Let's understand this with an example. Imagine that your tenant doesn't pay rent on the first of the month. You'll wait a day or two thinking maybe it's a simple mistake, but then nothing. Before Bill 60, you would serve a written notice called an N4. This gives the tenant 14 days to pay what they owe before you can even apply to the board for eviction. After Bill 60, well, it's still the same notice because tenants deserve a fair chance to pay what they owe, but now the waiting period before you can take the next step is about 7 days instead of 14. Your financial risk window is cut in half. Let's take another common example. Let's say you buy a home with a basement unit, but a year later your circumstances change, like maybe a parent needs to move in. Before Bill 60, even if you gave the required notice, you had to pay the tenant at least 1 month's rent as compensation. Now, with 120 days notice, that compensation is no longer required, making it much easier and less expensive to reclaim the home you own. One more change that matters. Tenants used to be able to delay hearings by suddenly adding complaints about repairs at the last minute, even if the case was about unpaid rent. Under Bill 60, the board can now require tenants to first pay a portion of what they owe before additional complaints can be considered. This avoids stalling tactics and keeps things moving. And finally, if the board made a decision, tenants used to have around 30 days to request a review. Many would file an appeal on the last possible day, buying more time while still not paying rent. Today, that window has been reduced to roughly 15 days, meaning outcomes become final sooner and landlords aren't stuck waiting. So yes, tenants are still protected as they should be, but landlords finally have a clearer, more predictable process. However, legal protections only help after a problem has begun. The smartest landlords avoid most issues long before anything becomes legal or financial. And the place those issues start is usually inside the home, in the daily dynamics between you and the person renting your basement. When you rent out your basement, you and your tenant aren't living separate lives like people in a condo building. You share walls, driveways, and routines. You will hear footsteps above or below. You will notice when someone works late and comes home at 1 a.m. and you definitely notice strong cooking smells. Such things can turn into frustrations if expectations aren't crystal clear before moving in. That's why choosing the right tenant is one of the most important financial decisions you can make. And one of the best ways to protect yourself is to run a proper tenant screening before you hand over the keys. That starts with a credit check. In Ontario, it's perfectly legal with consent to run a credit report through a major bureau or through a platform designed for landlords. A clean credit history gives you the confidence that the tenant pays bills on time. Beyond credit, always ask for proof of income, a recent employment letter, job details, and 2 or 3 recent pay stubs, or bank statements if the person is self employed. This tells you whether the tenant can comfortably afford the rent. A service like Single Key can make the process even easier. With the tenant's consent, it pulls credit history, verifies identity, and income all in one place. When you verify credit, income, and rental history, you reduce the risk enormously. You move from hoping for a good tenant to choosing one. And once you find the right fit, put everything in writing. A friendly handshake may feel enough when everyone is smiling during the viewing, but a written lease is what keeps both sides aligned if things change later. Without documentation, you might not be as legally protected as you think. Now, just as important is making sure the basement you plan to rent is itself truly legal. A beautifully finished basement can still be completely illegally built. A legal unit meets fire code, has proper exits, working smoke and carbon monoxide detectors, correct electrical approvals, and complies with the local bylaws. If something goes wrong, then the landlord is responsible. Fines for illegal suites can reach into the tens of thousands of dollars. So yes, Bill 60 has made the rules more fair for landlords, but your success as a landlord comes from preparation, not legislation. A legal basement suite, a screened and qualified tenant, a clear written lease, open communication, and a financial buffer for surprises. If you get those fundamentals right, then a basement apartment becomes a strategy, a way to pay your mortgage with breathing room instead of stress. It helps you build equity faster, improve your cash flow, and create long-term financial security. I'll include a link to the landlord and tenant board in the description. That's your go-to resource for all official forms and rules. If you found this video helpful and you want to understand Canadian real estate and long-term wealth building in a deeper, more practical way, then make sure you hit the subscribe button. I post research-driven content to help you make smarter financial decisions, whether you're planning to buy a home or invest for your future. Thanks for watching, and I'll see you in the next one.